agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Michael Baranowski, a professor of political science at Northern Kentucky University. I'm joined today by my conservative counterpart, Cleveland area attorney and defender of freedom, Jay Carson.
Hey, good morning, Mike.
Hey, Jay, how are you doing this week? This morning, today, whatever.
This morning. Gosh, I thought I'd have something clever. Because, I wasn't thinking, because I'm going to be doing the story intros, so I forgot to come up with something clever.
And I got to say to folks, I really appreciate it.
It's been a hell of a week.
Yeah.
I guess that's all we can say, right?
Yeah. And the reason why Jay is going to be doing the story intros this week is I asked him if he could do that because I am currently recovering from COVID. So if you hear some weird little sounds on my end, I will try to mute out and take out everything I can. But I'm still feeling a little bit, more than a little bit rough at times. And so please bear with me, accept my apologies in advance for that.
But I was going to say, like an injured Kirk Gibson stepping to the plate in the ninth inning of the '88 World Series, or the flu-ridden Michael Jordan coming off the bench in the NBA Finals. But you're here for America now.
I am absolutely here for America now, and of course we have an awful lot to talk about today. With the first thing we're going to be talking about, obviously, is the Supreme Court abortion ruling, the guns ruling, maybe the Senate, the congressional vote on actually firearms legislation. We'll see how far we get past that. I don't know, but we do have a lot to get into, and we are going to get into it in just a few seconds here.
Okay, our first story is obviously the court's decision in Dobbs versus Jackson Women's Health Organization. This may be, in some ways, Mike, it's the biggest story we've done since we started doing the show. On just yesterday, the court ruled 6-3 to allow Mississippi's 15-month, geez, that'd be a while.
Yeah.
Completely changed the game playing field. Ban on abortions after 15 weeks. Now, the court's 6-3 decision did not necessarily eliminate all of Roe versus Wade, but the court's 5-4 decision did. The Chief Justice essentially said he could have reached, or the court should have reached, a decision that could have still upheld the Mississippi law while maintaining some vestiges of Roe and or Casey. Interesting. The dissent was not surprising in that the argument was this will lead to the pullback on other rights. Of note, and this is something we'll talk a good deal about, I think, is Clarence Thomas's concurring opinion, in which has been taken to suggest that there are other rights on the chopping block. Mike, I think you and I are going to read that much differently as we talk about this. But I with no further ado, I guess we should get into this. The court's notion. The way it phrased this, the whole opinion, including dissents and appendices and all that, is some close to 250 pages, which can take a chunk out of your Friday afternoon. But what they do is the court walks through, first of all, its jurisprudence on how it got to Roe, and then talks about stare decisis and the factors that courts look at when determining whether to overturn a precedential ruling, walks through that and determines that there is no way that Roe can stand. And I guess Mike, that's maybe my first thought is to pitch that to you is, what did you think of the majority's opinion on this, on the analysis of the stare decisis analysis?
Yeah. And I should point out, right, there were it was a lot better in a sense than Roe, because there were only 5 opinions, right?
Right.
The majority, the dissent, and the 3 concurrences. But on that specific issue of precedent, I mean, I think certainly the idea that stare decisis means that you never overrule anything is, of course, just patently false, right? Because plenty, and that's why, in fact, the court.
And it's not. Yeah, the line is that stare decisis is not an inexorable command.
Inexorable command. There you go. And so I mean, if you accept the majority's reasoning that that Roe is as bad, basically, as Plessy versus Ferguson, that it is one of the most egregiously horrible decisions in the Supreme Court's history, then of course you don't say, but it's been around for a while. That makes no sense. So yeah, I think if you're arguing that it should stand just on precedent alone, that makes no sense at all, certainly. And I think that the majority does a good job of explaining under what conditions precedent can and in fact should be overruled. So I didn't really have a problem with that. Of course, you have to accept the fundamental argument that this was a horrifically poorly decided and wrongly decided thing, right? So, but it seems to me that the way I kind of conceptualized all this, because we both read the whole thing, and there's an awful lot going on here, right? It's not as messy as Roe, but there's still a lot going on, and it seems to me that here's how I interpreted the majority opinion, that substantive due process is okay, but it only applies to the first 8 amendments or unenumerated rights that are, in the words of the opinion, deeply rooted in the nation's history and tradition at the time that the 14th Amendment was ratified.
Right. And that's not necessarily anything new.
Well, we can get into that. But then they go on from that base to say, well, abortion isn't that, right? And that this is not something, even if you argue that there might be some sort of right here under substantive due process, which we're not throwing out, unlike Justice Thomas, we'll get to that this is not, we look at the historical record and we find that at that time that abortion was not deeply rooted, and that therefore this is not something that's a right in any way in the Constitution, and so it reverts to the states to decide through the democratic process. That to me is kind of the fundamental argument that the majority is making here.
Yeah, no, I think that's right. And just to walk through real quickly the 5 factors, because I know you like enumerated factors.
Yeah. Oh yeah.
But in looking at whether to overturn a decision, the factors the court looks at are: 1, the nature of the court's error. How bad is this? Second, the quality of the reasoning. Third, workability. Is the proposed order actually workable in practice? Effect on other areas of the law. And I lost 5. Like I'm paging through. If you can see my desk, I have 5 reliance interests, which I should have known off the top of my head. So those 5 factors they went through, and they said, 1, in terms of the nature of the error, the magnitude of the error, they said this is pretty big, because this very much looked to be a decision that is not really tethered to much in the Constitution, and it was a really big statement. It was not some small matter. The quality of the reasoning, that goes to say again what it was tethered to, and they criticized Roe and also Casey on that front. That again, there was not much constitutional analysis. There was sort of this, this right kind of sort of exists under the 4th Amendment, 9th Amendment, 14th Amendment. You pick any combination thereof, and that was a little slipshod.
So Casey more firmly grounded it specifically in the 14th Amendment. And I think
Correct.
Before I go further on this, let's maybe a lot of listeners probably are aware of this, but how we get from the 14th Amendment to the argument for a right to terminate a pregnancy might not be entirely clear on the surface of it. I mentioned substantive due process, and to me, this is really critical to this argument either way. And it's the idea that the 14th Amendment, Jay, as you well know, of course, says that that has due process protections, that you can't be deprived of life, liberty, property without
Yes.
due process of law. Now, that means two things. Well, at least one thing. It means that procedurally, the state just can't come in and say, hey, we're going to lock you up or do stuff to you without some sort of, process.
You get notice in a hearing.
Exactly. That's procedural due process. Now, substantive due process is this idea that there are certain things that just simply can't be done that are kind of fundamental to ordered liberty and deeply rooted.
The concept of ordered liberty.
Exactly.
Yes.
And so even if you have a process, you still can't do it.
Our system, ordered liberty, I think is the word.
And that's this notion of substantive due process. And so then the question becomes one of, if there is this substantive due process that refers to things that the state cannot do, but these things are not enumerated in the Constitution, how do we know what they are? Right.
Yeah.
And that's where
and then the one response is, we look to history and what was sort of assumed and treated as a fundamental right at the time it was adopted.
Exactly. And that's where I say the majority says that, abortion isn't that. Now, the dissenters, they of course, Breyer's dissent, they certainly agree that substantive due process is a real thing and should be, but it also applies not just to whatever the traditions and history was kind of at the time that amendment was ratified, but the dissenters argue that our history and our traditions change over time, and so therefore that our understanding of what is covered, in essence, under this notion of substantive due process in and of itself will change over time. And that's more of you talk about that.
Like a living constitution.
There you go. That's the sort of thing. And that's so, but even more than that, the dissenters would argue that the majority is wrong in its reading of even the prior history, and saying that, the majority kind of cherry picks these things here and there and says, there's nothing rooted. But the dissenters make arguments about, there weren't these prohibitions against abortion prior to quickening, as it was called, and so forth. And so they argue that in effect means that there was something that was deeply rooted. And the majority comes back and says, wait a second. It's one thing to say
that was based. Yes, I'm sorry. Go ahead.
It's one thing to say that something was not legally prohibited, but to say that there's not a law against it means that there is a right that is deeply rooted. Those are two different sort of things, and that's not an unreasonable argument.
Yeah, and also if you consider the quickening argument, which actually is something I want to talk about sometime, and we might get to it, might not get to it, because it's not even necessarily a political argument. It's more just a weird personal thing I was going to throw in. But, that was, in effect, the only measure that they had in those days. At the time, it was the 14th Amendment was ratified.
Right.
Again, quickening meaning, that you can detect fetal movements.
So, but if we kind of continue on with this, maybe is the place to get to, just because I'm on the sort of substantive due process thing, right? That there is Justice Thomas, who agreed with the majority decision, but said, substantive due process is just junk. It's nonsense, and we should not rely on substantive due process for this, because it's not anything. And he's right. It's nothing that's actually in the Constitution. It's just something that was made up basically by the court. And he says, and not only in this, but hey, let's actually we should overrule everything that relies on substantive due process. And that's what a lot of folks on the left especially were freaked out about. And he says, what does that mean? Well, we'd have to take another look at our rulings on gay marriage, on sodomy, on same-sex marriage, sodomy. There's other big one I'm blanking on right now. It's Lawrence Obergefell
contraception.
and contraception. Yeah, there you go. And now here's an important thing we need to bring up here, though, is that if you actually read Thomas's dissent his concurrence, as opposed to just cherry picking, what you'll find is he doesn't say we should overturn all these cases. What he's saying is that we need to look at them and see if there is some other grounds for arguing that there is a constitutional right. Now, this has been actually Justice Thomas's kind of lonely, quixotic quest for quite a while now. He hates substantive due process with the fiery passion of 1,000 supernovaing suns. But he's kind of he's a lone wolf on this. There's, I think, some instance that I believe it's Justice Gorsuch was like, well, you're not entirely crazy, but this is a pretty radical type of, and Justice Thomas, he is a conservative, but he is an activist conservative. He always has, well, not always, but he's very comfortable saying, hey, let's just throw everything out the window and do it this way, which makes more sense to me. And so he's kind of like the anti-justice, Chief Justice Roberts in that sense, right? But this idea that all of these rights are going to be on the chopping block, I think I understand the argument here, but I think that it really doesn't keep in the mind how very radical Justice Thomas is, even on that court. Because, I mean, no one joined him in this concurrence, right? Not even Sam Alito was like, oh, well, let's not even go there, right? So, yeah, I think that's just Justice Thomas being Justice Thomas.
No, I would say that's exactly right. And it's a weird thing with this conversation because there's so much to talk about. I wasn't sure what we'd get to when or where we would steer it, but yeah, on Thomas, one, I think the media and Democrats have been sort of misinterpreting what he said, and it falls to us because to provide context for his statements. And yes, he has always and forever hated substantive due process. And it's a largely academic argument, right, that he's making, that he says, well, substantive due process, we shouldn't rely on that because it is just a completely kind of court-made-up doctrine. And because it's a completely court-made-up doctrine, there is the danger of courts in inserting their own policy preferences into that doctrine. And this goes back to sort of its origins. Mike, you're well familiar, and maybe our listeners are, with the case of Lochner versus New York. And this kind of goes back to the beginnings of substantive due process. And in Lochner versus New York, Lochner was a guy who worked at a bakery. New York imposed certain hour restrictions. Lochner said, no, I want to work more hours, and I have essentially a liberty interest in doing this because, look, the Constitution does have a contracts clause that says the government shall not impede contracts, which has never been interpreted to mean the government can't make certain contracts illegal. But there was sort of the idea of, well, if you kind of squint and look at that and take it in the context of the 14th Amendment and other these other provisions of the Constitution, well, yeah, I have a right to contract. A constitutional right to contract, and that's what the court decided. And Oliver Wendell Holmes famously dissented in that, saying the Constitution doesn't recognize any one economic theory over another. And then, Lochner was a case in the 20s, and then almost immediately, not almost immediately, but immediately in Supreme Court terms, they started to backtrack on that and say, no, this wasn't really what they meant. And it sort of became the term Lochnerization is sort of a it's sort of an insult. If you're accused of Lochnerizing, that's sort of them's fighting words. So they moved away from the substantive due process in economic rights, and then sort of reopened that front in later cases, such as Griswold, which then flowed into Roe. But Thomas's point is, look, none of this is that's the very issue. Is if you have justices who are maybe of a mindset that they are more likely to find these economic substantive due process rights, that they're injecting something that isn't in the Constitution. Likewise, if you have justices who are more apt to find these other social or personal autonomy, I guess we'll call them substantive due process rights, that's not in there either. And the intellectually honest thing to do is just say, this is all a load of crap. And his preference would be incorporation of these other rights based on the Privileges and Immunities Clause of the Constitution.
And and just to be clear, which
again, we're getting deep in the
and what Jay means by that is the rights that we tend to think of as our rights as citizens of the United States, freedom of the press, religion, right to bear arms. None of those things, recall, initially applied to the states. They were rights you had as a citizen against the state in terms of the federal government, but the states could do whatever the hell they want. I mean, depending on what was in the state constitutions. And so over time, these rights were held to also, these protections were also held to apply to protections against the state as opposed to the federal government.
Through the 14th Amendment.
Through the 14th Amendment.
Yeah, it was the 14th Amendment that worked the magic that essentially said, oh yeah, all your Bill of Rights and all your other rights that we've recognized as against the federal government, those also apply to the states.
Yeah, but that is also judge-created law. That is, it says Congress shall make no law, not the state legislature shall make no law. Now, what Justice Thomas is saying is that, well, if we just go one sentence before in the 14th Amendment, it says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And there we go. That's actually that's a much clearer sort of grant of, or a much clearer instruction, if you will, than this kind of, we'll call it substantive due process sort of thing. And, like I said, I think
it's the more intellectually honest approach, but I think that ship has sailed.
Yeah, absolutely. Absolutely. I agree. So I think from a strictly kind of theoretical point, Justice Thomas is maybe more right than anyone else who wrote on this, in this opinion, but that doesn't mean I think we should do what he suggests for all of the reasons that I'm sure Chief Justice Roberts could go on at great length discussing. Yes.
No. And again, you do get this sense of, oh, there he goes again. And it's the other thing is I think important to note. If you read Thomas's concurrence, the cases he cites to, he sort of cites to himself in all these prior dissents. Where it is sort of like, look, I've been telling you guys for 30 years that the substantive due process is a load of crap. And again, he's not entirely alone on that. If you Google substantive due process is a load of crap, you'll find plenty of scholarly articles that'll say more or less that raise those kind of arguments. But yeah, I think the sense that this is there's certainly nothing that any court would rely on, and Thomas says this, would rely on to turn back other rights. There's nothing in this case that somehow makes it precedential that you can then go back and say, well, Obergefell was wrongly decided.
Yeah, and certainly in Justice Kavanaugh's concurrence, a big part of it was, or at least a part of it was, essentially pay no attention to Justice Thomas here. Right. That we're not saying
that's crazy uncle, and he's always saying that.
Yeah, exactly. And I get how if you assume that the 6 or 5 of the 6 conservatives on the court have a bad faith agenda to basically try to roll back the clock on rights to 100 years ago or more, then you're just going to assume that this is a cover and this is just the start of a slippery slope. And I get that. If you start from an assumption of bad faith, then that totally makes sense. That's not where I start from, at least. I think really pretty much with all of the justices, actually. I accuse them of a lot of things, but I don't really think that bad faith is one of those things. And I know that this is where I depart from, say, Ken and a lot of other people on the left. I just think that they view the Constitution in a fundamentally different way as I do on many issues, but that it's not inherently wrong. They're just starting from different kind of suppositions.
Well, or that there's, there's somehow the master plan that conservatives will elect all these justices so that one day they can enable states to ban contraception.
Well, that being said,
I go to Republican events, and that's the first thing out of people's mouth is like, when are we going to? It's just sort of nonsensical.
Well, that being said, I think that's where we have to ask the question of, well, what does it mean to turn this? If there is in fact no, as Justice Thomas would argue, no constitutional right to say contraception, because I can't imagine an alternative section or clause in the Constitution. If there is no right to contraception, if there is no right to, if the state can freely ban or criminalize sodomy, and I think that certainly is an argument you could make, then what does that mean? Does that mean that governments that will start to ban that sort of thing? I would expect not. And certainly, I have to say that this is going to come off as me.
I would more than say expect not.
Well, yeah. There are some areas where I don't know. Some jurisdictions. There are some states where I could sort of see. If in Mississippi, some legislator introduced a bill to criminalize or recriminalize sodomy, I don't know if that wouldn't actually pass. So that I think is a serious, not a trivial type of concern. Now, I think if that sort of thing came before the court would rely on sort of the, I think, faulty logic that Justice Alito cited here, saying that, well, we don't have to worry about this logic applying to other things because, well, abortion is different. Now, if you track that,
I wanted to point out, I don't want to interrupt you, but this is good because I wanted to point out that you and I had a very similar conversation on this a couple months ago. Where you asked me a number of times, say, listen, is there, if you accept a right to privacy as part of substantive due process, or that substantive due process, assuming it exists, encompasses a right to privacy, does that not necessarily lead to a right to abortion? And my answer, and I think your agreement was more or less along the same lines as where the majority came out.
Well, here, no, actually,
even where Roberts came out a little bit, right? That you can recognize privacy, but not abortion.
No, I think the majority is being incredibly intellectually dishonest here. I think the logic at this particular point is just absurd, because what they're saying, again, this is an argument, a substantive due process argument, and the test is this right? Is this alleged right deeply rooted in our history and traditions? If it is, then okay, it is covered. If it isn't, then it isn't. There's nothing, this weird little sidecar of, well, abortion is different.
Competing interests.
Yeah, no, that's specifically what the court said they wouldn't consider, that every single circuit court that ruled on this got wrong, that no, there's no competing interest test here. We strike this entirely. And so if you follow the court's logic, then this would mean, if the court followed its own logic, then it absolutely means, there's no question in my mind, if they were being intellectually dishonest, that if there were a sodomy law, they would uphold it. If there were or an anti-sodomy law, they would uphold it. They would overturn the gay marriage ruling. Absolutely. But my point here is that they specifically inserted this erroneous logic in the majority opinion so that they could go back on this and say, well, we don't actually have to overturn these things. So it's intellectually horrifically dishonest, and Alito is smart enough to understand that, and other people who signed on to it, but they just don't want to go there, basically. And that's, if you're on the Supreme Court, you can use bad logic to get to a preferred result, which is exactly, of course, what they were arguing that the majority in that the court in Roe did. They're doing the same thing here. Just the difference is that they're kind of walling off abortion, but they're doing it in a way that really doesn't stand up to any kind of logical scrutiny.
So you would go. I mean, I'm not putting words in your mouth, but it's almost like you would say you'd prefer that Thomas, intellectually honest, substantive due process is a load of crap. It's all got to go.
Yeah, I mean, I think that's the only.
No, look, I agree with you that is more consistent. I wouldn't go so far as to describe the majority's decision as intellectually dishonest.
I would say not in its entirety, but on that point.
Yeah, no, look, but I agree. They're putting in an exception that wasn't necessarily there before.
Yeah, right.
Exactly. I think that's a good distinction. I think that's a reasonable distinction that you can make.
But they're putting in a judge-made berm, if you will, or firewall that has no basis in the Constitution. Which is, I mean, so they're creating.
So I wouldn't, but I would argue that there is a basis in the Constitution.
Okay.
Because we talk about life, liberty, or property, and I think you can make the argument that there is a competing interest in life, in an abortion case that there is not in some of these other instances.
Well, I don't necessarily disagree with that argument. And like you said, we've made that argument a number of times. But of course, in very forcibly and very clearly in the opinion, Justice Alito dismissed that argument. And so that's, I guess, the crux of it.
Not really. I mean, I think he sort of says abortion is different because there's a competing right.
No, in fact, he said, if you read, he said specifically, we should not consider competing rights. This whole notion that when circuit courts have taken a look at this case, they've looked at history, which is correct, and then they've looked at this sort of I forget how they put it, this weighing argument, and that is totally incorrect and unacceptable. And so they threw that out very specifically. And that, I think, if you're going to do that, well, then you can't do that just for this. You have to do it for everything. So
I'm looking to. So here I'm pulling up the. This is page 37. If you're playing along at home. So first, if the long sweep of history imposes any restraint on the recognition of unenumerated rights, then Roe was surely wrong, since abortion was never allowed except to save the life of the mother in a majority of states for over 100 years. And then he says it's impossible to defend Roe based on the prior precedent because of the precedents Roe cited, including Griswold and Eisenstadt, were critically different for a reason that we have explained, none of those cases involved the destruction of what Roe called potential life. So to me, I think he does put in that additional factor that this is abortion is different, and this is why. Now you can say that that's.
No, I'm not. We're not disagreeing. We're not disagreeing on that. But I'm saying that it's just something that he made up. There's no constitutional basis for that.
That is not part of the test that was
exactly
previously in place. Yes, I agree on that. Yeah.
And so that's what I mean about it being, and there's no way he doesn't understand that. And so what I'm saying is that the majority said, well, listen, we really want to overturn Roe, but we don't want to follow our logic to its natural conclusion, which is what Justice Thomas, Thomas actually goes one step further, right? Because Thomas just says, let's throw out substantive due process entirely.
He would, yes, throw out an entire body of law.
But yeah, exactly. But what the court's saying here is that we are announcing this test for what actually is covered by substantive due process, and Roe does not, or abortion does not meet this standard, but neither would contraception, neither would anti-sodomy laws and so forth. They don't talk about that certainly, but Justice Thomas certainly would agree. It's weird. Justice Thomas would agree with me on this.
But isn't it part of the court's job to draw these kind of distinctions and to say, look, this is why X is different than Y.
It's important to draw.
Those precedents don't apply here.
Well, see, yes, I would say, but if you are a so-called conservative justice arguing that Supreme Court justices should not be making up distinctions just out of whatever they happen to want to do.
Stick to the test.
If your argument is that, hey, we interpret the Constitution and we don't insert our own preferences, well, then I think it's a lot harder to make that kind of argument. Whereas if you're a justice on the left saying that, well, we need to consider more than just the text as it was understood at the time, then it's being a lot more intellectually consistent if you want to go with consistent as opposed to honest and dishonest, and maybe that's a better way to do it.
No, I think that's yeah.
So yeah. We still have a lot more to get into here, but let's just take a quick break and we get back to Justice Roberts. I definitely want to talk a little bit about Justice Roberts' concurrence because I think that was pretty important as well here. Okay, Jay. So sorry for that. Sorry for that brief break, folks. It's only so much that Mucinex and Halls can do for a person. So anyway, but
now, let me throw in. I want to make one self-correction. I said Lochner was decided in the 1920s. It was actually 1905.
Oh, there you go. Okay, even.
But I was thinking of Atkins versus Children's Hospital of D.C.,
Okay,
which
yep.
was minimum wage, which was 1923.
Got it. So, I want to talk about Chief Justice Roberts. I feel for the guy, because his concurrence, I think was important. I agreed with it, but I disagree with it. First off, the Chief Justice argues that Mississippi basically pulled a bait and switch on the court. Right, because in the initial arguments, they said, "Hey, listen, you don't have to overturn or even consider the constitutionality of Roe versus Wade or Casey to allow for our law to stand. And in fact, we're not even asking you to do that." But then at oral argument, I believe it was, they said, well, actually, maybe you should do that, right? That would be a better idea, essentially. And the Chief Justice says, well, listen, we granted this to look at these issues, and now we're all of a sudden going to look at broader issues, but we don't need to look at these broader issues to decide this case, essentially. And he had a great line on this. He said, if it is not necessary to decide more to dispose of a case, then it is necessary not to decide more.
Yes.
And
that's sort of a well-known, well-regarded principle, right? If you can avoid making a big constitutional change by making some other sort of interpretation. Justice Brandeis sort of set out what were called the Brandeis rules that were sort of a guide to conservative small c judging, and that was one of them.
Yeah, so I think the majority's response to this was interesting because one of the things we didn't get when we saw the draft opinion, when you see final opinions, you get to hear the justices talking or respond to each other's arguments. And the majority response actually sort of throws Roberts back at Roberts here. And Justice Alito writes, while the concurrence is moved by a desire for judicial minimalism, we cannot embrace a narrow ground of decision simply because it is narrow. It must also be right. And that was actually a quote from, Chief Justice Roberts actually concurring in a case. And so, here's the thing. I think Roberts was right, but in the sense that the majority's argument, I think, was maybe more compelling to me because what Roberts basically said is, we don't have to decide this now, but the majority says, but given all these other laws that are coming up, we are still going to have to decide this, and we just want to be done with this, and we don't want to kick this can down the road, basically. Now,
something else I was going to mention that the majority says is, and again, I think it's an interesting to note. I don't know that it's of huge constitutional importance, but that the respondents in this case argued that, the appellants argued that there was no middle ground. That they sort of told the court, look, if you agree to say that 15 weeks is permissible under whatever theory, under saying, that's not an undue burden, or some other version, right, that you get there and uphold 15 weeks but still uphold Roe, you just can't do it. It's all or nothing, because that would essentially eviscerate Roe. So there was sort of a doubling down. Now that's the court is of course free to adopt whatever reasoning and proposed remedies the claimants give them, especially the Supreme Court. So I'm not saying that's the court is there for somehow, it looks like we got to overturn Roe because these guys said so, or these sides. But I think that's interesting that was in the majority notes that a number of times.
And also I should point out, Justice Roberts suggested a different standard, what he called a reasonable opportunity standard. right? Because
Yeah.
his argument was that, well, what if instead his argument was that we can not overturn Roe and Casey if we just simply say, well, we can also uphold the Mississippi law, but we can't do that under the standard set in Casey. So we need a different standard, and his was reasonable opportunity. What he means by that is that the state must allow a woman to have a reasonable opportunity to obtain an abortion, and now that would basically move the clock back further, right? And so Mississippi would be okay. And I think Chief Justice Roberts mentioned kind of the sort of 12-week standard in a lot of other countries, and saying that, well, we could kind of fit in there and we wouldn't have to do anything big. This would not be the phrase he likes, a jolt to the legal system. And I think he's right in that, but that also is not the most intellectually clear and honest decision, because I think the majority is right that sort of that standard of undue burden and viability are more tied up in Roe and Casey than you'd like to admit. And so I don't necessarily object to the Chief Justice's solution, in a sense, this standard, but I think that to do that, you would also have to clearly affirm that there is, in fact, a right to obtain a right to terminate a pregnancy,
which he seems to do, right?
But he doesn't really want to. That's the weird thing. I think if he were pushed on it, he'd say, "Well, no, I don't actually think this is the right. But, geez, guys, do we really have to decide this now?"
Come on, guys.
Yeah. How about if we just sort of massage this sort of thing? And I get that, but it leaves me feeling that's John Roberts, right? He likes to kind of chip away at these things, but not make these big changes. And I have a lot of sympathy for that, because I feel like his general inclination toward judicial minimalism and incrementalism is fundamentally right. And at one point he says, and at one point he says,
so does he?
Yeah,
right?
exactly.
I wrote it before. Yeah.
I mean, at one point he says, I just simply do not share the certainty that either the majority or the dissenters share. And I'm like, yes, I'm with you there, buddy.
Right.
And I think that's what judges.
I would respond, but you are the Chief Justice.
And so my heart is with John Roberts on this, and I would love my perfect Supreme Court justice would be John Roberts, a left of center John Roberts, But my heart is with him, but I just think that it doesn't quite work the way he would like it to kind of work out, basically.
So what strikes me in the Roberts opinion in reading it is a couple things. A couple times even goes back to mentioning, look, you're kind of within the second trimester, and he says, like, look, I think we could overturn the tests in Roe and Casey, but then he starts talking about trimesters, but still uphold that there's a right to abortion that's established there. And to me, and then he talks about limits in other countries. And once you start talking like that, to me, that sounds for all the world like a legislative compromise. And I think that might be a good legislative compromise, but it's not constitutional judging, right? And I think that's the thing. And I also, again, my heart goes out to him in terms of I appreciate the humility, right, in his statement that look, I'm not entirely confident of. I want to pull up the actual line because. Well, you may have.
Well, while you're looking for it, I'd say that word.
I will. Okay, yes, you talk.
That word humility, I think, is really important because it is a word we do not associate with many political figures, and the fact that we can, I think, reasonably attribute it in many instances to the Chief Justice is something to be said very much in his favor. As I've said a bunch of times, even though I would often reach different conclusions from John Roberts, I feel that his overall sort of general philosophical approach is one that I feel comfortable with, I guess. So anyway,
so the line, and I like to repeat these things just because, again, there's so often in our country we've lost poetry, right? But every once in a while,
God knows you're not going to hear it from us. Yeah. So yeah.
Yeah. No, but no. His statement is both the court's opinion and the dissent display a relentless freedom from doubt on the legal issues that I cannot share. relentless freedom from doubt. So I get that, right? And on a very personal level, abortion, I think, for so many people, that would be, if you were to define their position in those poetic words, a relentless freedom from doubt. You know what I mean? But at the same time, like I said, you're the Chief Justice. If you're not the guy, to weigh in on legal issues, then who is? Right?
Yeah, and so here's where I come out on this, because I've thought, obviously we've talked a lot about this over the years, this issue, and I've spent an awful lot of time recently thinking about it. And so I first of all, I guess I want to preface this because people might be upset. I don't know, but I think we should point out, I'm going to point out at least, that there's oftentimes a distinction between what is constitutionally protected and what is or is not morally right or wrong. There are things that are hugely important. There are things that ending the protection of would be incredibly bad. That doesn't mean that they're constitutionally protected. We've talked about this in a lot of contexts, right? Good does not mean constitutional. Bad does not mean unconstitutional. And so I want to say, I find it, not just deeply concerning, but completely morally unacceptable, morally repugnant that in multiple states after this ruling, a woman who's raped, a victim of rape, a victim of incest, will be forced to carry that fetus to term. That turns my stomach. And if I were in Congress, I would right now be working on some sort of rape and incest victim protection act that would kind of deal with this. I also would be a huge fan of a constitutional amendment somehow codifying abortion rights. But that said, okay, when I look at the constitutional arguments and the text of the Constitution and everything surrounding that, where I come down on this is, and it's hard for me to say this because it's so counter to my policy preferences and to what I believe should be rights, I come down with Justice Thomas on this. And I hate the fact that I do, right? Because the logic of Justice Thomas leads me to a place that is just, I feel, deeply wrong morally. But that's where I end up if I'm just looking at the Constitution, and that's a weird and deeply disturbing place for me to be. But that's where I end up, because when I ask myself that question, well, if I were on the court, how would I have ruled on this, and whose opinion would I have joined? And the only one that anyway, I'm in a weird place.
Striking down contraception.
Marriage,
gone.
I'm in a weird place here. I don't like being in this place.
Maybe it's the COVID.
Maybe
long COVID, Mike.
But I'm sure you see what I'm saying here.
Yeah, no, I do, and I was going to make the same point because there are a number of these state laws, right, that are kicking in automatically upon the overturning of Roe versus Wade, that do not contain rape or incest exceptions. And I was thinking a lot about this as well. And the result that I came up with is sort of similar to what you just said, although I'll put it in a little different terms. The court's job isn't to determine policy or morality. That is a job that's better left to the legislature. So, and I can understand from a constitutional standpoint, you would say, well, no, there isn't a constitutional right to abort your fetus in case of rape. What's the constitutional difference, right, between someone who is pregnant by rape and someone who is not, right? You're not going to find any text anywhere, even, substantive. Well, maybe you can find some sort of substantive due process right there, but still, that's just not in there. And that's part of the reason why we have a system that we do, where the emotional questions, the right and wrong, the morality questions are more left to the legislature. And there's always this saying that, well, you can't legislate morality. But of course you can. We do it all the time in any bazillion number of ways. And the morality that we legislate is sort of the collective morality that comes out of the democratic process, right?
And I agree.
So I think there's the place for that, right? I very much agree. There's a place for that, and I think we're sort of on the same page here that ought to come through the legislature rather than the court.
Well, yes and no. I agree with you to that point, but I also believe that there are certain rights of persistent minority groups that need special protection because of always, of course, one concern,
Sure.
right, in a democratic system is that the majority can legislate away fundamental rights of the minority, which is why we have a Bill of Rights.
I think that's kind of already in what I'm saying is I think you could find constitutional provisions to protect that or protect those rights.
I don't think so. I don't think you can find clear constitutional provisions to protect people who don't have kind of what we call standard sexuality. I don't see any constitutional provision based on kind of a Justice Thomas sort of.
Oh, no, okay, I get what you're saying.
And so,
here. Yeah.
Therefore, we have this consistently oppressed minority group, right? That they have no recourse. And if you say, well, rely on the democratic system, that's great, except that might work really well in California or New York. But if you're in Mississippi or Alabama, well, then that's just too bad. And so that's where I understand the desire of a lot of folks on the left to say, well, let's just say that people have these rights. And that's where you kind of get into evolving
we have a fundamental
constitutional.
right to X.
Yeah. And I think that these are fundamental rights, but I think that they would be more clearly and sort of logically consistently enshrined if they actually were rights that were clearly enumerated in constitutional amendments. And that's not going to happen. And so I get the argument saying that, well, what are we going to do then? We can't just leave this at the whim of majorities, but we're basically leaving it at a whim of a smaller majority of 5 or 6 justices on the court, right? So it's not an ideal situation no matter how you look at it. To me, the ideal outcome would be reproductive rights amendment to the Constitution. I know it's not going to happen.
Yeah. No, I would agree that is the intellectually honest way to go, and I think there would probably be some support for something like that, right? There have been these polls showing that people support Roe versus Wade, although it's not entirely clear if they understand the question that they're being asked.
Yeah,
right?
exactly. I think that's.
But I think by and large, if you made the proposal, listen, would you agree to that abortion should be legal in the first 3 months? Now, again, is there any constitutional rationale why it's 3 months and not 4 months or not 2 months? Not really, but this is a legislative decision, right? So you don't have to have a constitutional rationale. It is that balancing and compromise of people working this out.
Or if I suggested about the rape and incest thing, I think it would be it's certainly plausible that one could get one could get certainly a majority in the House, obviously, for this right now, because we got but I wonder in the Senate if legislation were introduced like that, if that would actually overcome a filibuster. That's a sort of an interesting question. I don't know if we'll find an answer to that, but I think it would be sort of hard for a number of Republican senators maybe to sort of defend a vote saying that, well, no, I think that rape, if you're raped or if, someone, that I think that would be hard to defend. And I hope that Senate Democrats will force that issue, because I think it's an issue that should be forced. If you don't think that's something that should be enshrined in law, then you should be on record as having to have supported that. Well, if you're raped, then you should have to carry the fetus to term.
Yeah, no, I agree with that. I think that's, and to me, that is what's good about this opinion in the place where we are, is it does push these issues back into the legislative realm, which I think that's the better place for them to be.
Yeah, and ultimately,
right? Because look, it's going to be ugly for some time as we fight these things out. But I think a consensus will develop, and it's like the quote I've thrown out a couple times. from Judge Sutton of, would you rather be governed under Brown versus the board or the 1964 Civil Rights Act? And the answer is the Civil Rights Act.
But and I understand your argument here, but again, the frustration, the deep frustration of a lot of folks, especially on the left, is that, but I believe
we want it now.
No, but I believe this is the fundamental right, and the fundamental right shouldn't change just because you happen to have been born or lived in Mississippi as opposed to California, and that's absolutely the case. And so that's why I think that that this is not something that should be, this is something that should certainly be run through the democratic process, but that should not be a matter of law. That should ultimately be part of the Constitution in clear, unambiguous language, so that in the future, it doesn't matter how conservative or anti-woman or what have you, whatever phrase you want to use, the majority of the court is, they will not be able to look at this and say, oh, no, women do not have the right to terminate a pregnancy, because it is here clearly and boldly in the Constitution. Right. And that to me is that would be my ultimate goal.
Okay. Well,
but again, the problem is the process is designed, the amendment process is designed in such a way that would simply not be possible in any way, any world I can imagine. And that's the frustration, to me at least. So, let's talk a little bit. We're kind of getting into the politics of this. Do you see this? President Biden, said that the battle is not over, and there's talk about how this might affect the midterms. Well, what do you think about that? Do you think this is going to have much of an effect on elections?
I'm still going to say a little bit on the margins. Again, same thing we said about when the opinion leaked. I think this energizes the Democratic base to some extent, but those people who are really energized by this issue were already energized. I think there's going to be some maybe increase in intensity. I don't think it turns around the fundamental, it's the economy stupid issues, right? I still think the major issue going into the midterm is inflation in the economy. This will fire some people in the base up some, and maybe it helps you in a couple marginal House races, right, that are close calls. But I don't think it changes the equation fundamentally.
Yeah, I think I understand that reasoning, and to a large part I agree with that. I think it might actually have more of an effect in the slightly longer term, as more and more women kind of are in situations and realize, and the people who care about them, all of a sudden that, wow, this actually does affect me, and this imposes significant burden, and some of that's going to happen right away. We're seeing some of that happening right away. But I think, as that becomes more of an issue, then I could potentially see it being more of an issue in, say, 2024 than it is today, as people kind of, as you said, the economy.
No, I agree. I think that's probably right. Although, I think you threw out this number a couple weeks ago. If you look at something like 90% of abortions would still be legal if you do the math, right, going by the states where they occur versus states where they're banned. Now, I think that may have been taking into account.
Now, that's going to change.
And takes into account all those states that have the trigger laws. Yeah,
that's going to change. That's going to change a lot. And so that's what I think we're going to see much more of an effect as people start to realize that a lot of these trigger laws are 30 days and so forth. And I think much of this is going to happen too soon before the midterms, and along with that other bigger issue, at least to most folks, in the sense that it directly affects them, of the economy and inflation, for it to be less of a factor in 2022 than I expect it would be in 2024.
Oh, I think that's right.
Yeah. So there we go. Any other thoughts on this before we move?
Well, gosh, I mean, I could go on for quite a while. But I think we probably should move on.
Do you think? One other thing before we do move on, and before we move on, we'll have to kind of take our break. But I wonder about how long Roe stood for 49 years. Certainly there was a lot of folks on the right. There is a great deal of it took us a long time. It took us generations, and it was the result of a very thoughtful, calculated strategy, right, of developing a conservative bench, if you will, and kind of farm teams to get the court to the point where you could have this sort of thing. The Federalist Society played a big role in this, groups like Heritage and so forth. And so, I'm wondering now if the left, certainly the left will, I would expect, look to this and say, well, okay, we need to build our own infrastructure or rebuild our own infrastructure on this. And I guess I want to get your sense of what do you think the chances of the left doing this sort of thing to reinstitute a right to terminate a pregnancy as a fundamental constitutional right, because we both agree it's not going to happen through an amendment. Do you think that's possible? And if so, what sort of time frame do you think we're looking at for that?
So first, I don't know that I entirely agree with you that it's impossible to do through an amendment. I think it's unlikely. I think it'd be an uphill climb.
Highly unlikely. How about that, Bill?
But I wouldn't rule out the possibility. I mean, I think there might be a lot of people, if you pitch this right and said, here's what we want to do. We want to have a constitutional amendment that says. Now, I guess the issue is, would there? The issue is less, I think, acceptance of the amendment as who writes it and how it's worded, right? Because I think so much of the left has tied itself into abortion on demand, anytime, anywhere. That I don't
think that's true. No, I don't think that's true at all. No, I think that's the sort of the straw man, the sort of caricature of the left. But no, I think there were plenty of people on the left.
Were you reading the signs they were showing yesterday?
But those are. I do not think, generally speaking, that people who go out and make signs in front of the Supreme Court are representative of the left as a whole, any more than I think that people who stormed the Capitol on January 6th are representative of the right as a whole.
Yeah, but Chuck Schumer and AOC are basically saying that anytime, anywhere, and the abortion bill that they had floated, right? The congressional, what they were going to call codification of Roe, would have been that sort of expansive anytime, anywhere.
I don't think that's the issue. I don't think the codification of Roe isn't anytime, anywhere. It's pre-viability, and so that's not anytime, anywhere.
Well,
no, I mean it's not.
It's go back and talk about that.
As a matter of fact, let's not let this drop. Let's be clear. Roe or Casey do not allow or do not say that states can or that states cannot prohibit late-term abortions. That's never been the case. If a state wants to prohibit,
absolutely.
And so this codification of Roe that the House passed would still allow states to ban later-term abortions. So that's just a matter of fact.
Well,
I mean, no, it's not it's a matter of fact.
I agree with you on what the court says. I disagree with you on what the bill says. I think the bill would be much broader than what Roe or Casey had, but that's a conversation for another day, I think.
We do not have. I'll say this: we do not have the bill that the House passed in front of us. We won't stop at this point to pull it up, but I will say that I am fairly. I'm not Chief Justice Roberts uncertain. I am fairly certain, though not Justice Thomas certain, that Jay, that you're wrong about this.
Okay,
but
fair enough.
We will check.
We will check.
We will check, and we will discuss the next time we are on to clarify this. But
my point is, though, my larger point is, I don't see the will on the left to accept anything less than that, than a right to abortion anytime, anywhere.
I see what you're saying.
Amendment.
I see what you're saying.
And I likewise, I think you could get some on the right. You're not going to get everyone on the right, but you could get some who would say, whatever, 15 weeks or 20 weeks or 30 weeks.
And I get it. I think it's very common for us to see our side as having more reasonable people than the other side, and that's what I kind of hear you saying. I see it very differently. I don't, well, somewhat differently.
Well, I mean, I'm saying, look, the people of Mississippi, the legislature of Mississippi passed a bill that said 15 weeks.
Yeah, exactly. And I think that actually,
that's not, I mean, I'm saying that's
right. And you're saying that you think that there would not be enough support on the left for sort of a 15-week type of constitutional amendment because they'd say, well, it has to be all or nothing. And I think that you're wrong about that. But we'll
and there would be some on the right that would say, no, life begins at conception, and there can be nothing else. But what I'm saying is, if Mississippi would seem to be a fairly decent representation of the conservative mind on that.
I almost feel like, and this is going to sound weird, Jay, and it's one of those things where someone's probably already doing it, but and it's the idea that just a person would do this is weird. But I almost feel like that I should start some sort of a movement to put together, to draft what I would consider to be a reasonable reproductive rights protection constitutional amendment, because of course these things have to start somewhere, and you have a campaign and you get people behind it and that sort of thing, and that's crazy, right?
That's exactly what I'm saying. But I'm just saying the issue isn't. I think if that actually gets going, could it actually be accepted? I think there is a middle position that most Americans could agree on. Well, look, but I think it doesn't get out of the gate.
Well, let me say this: if I will make this pledge right here and now. If there are enough just listeners of the Politics Guys who think that they would like to see and could get behind and support in various ways, that sort of an amendment, at least in theory, I will happily devote all sorts of time to putting that together, to trying to figure out the infrastructure and that. So let me know, seriously, if that's something that you folks want to see, I'll be willing to do that, and we can kind of work on it, and maybe we can make something happen. I mean, we have a tendency to say, well, we can't do this because this is a big thing that, only people who are connected or rich can do. But maybe this is something that's worth trying to do. I think it is. And if you folks tell me that there's enough interest and support just among our listeners for me to move forward on this, I will absolutely devote probably what will amount to be a ridiculous amount of time to this, and we'll see where it goes. That's my pledge to you. So let me know what you think about that. You can, again, the way to do that would be, of course, mail@politicsguys.com, and that will work. Mike@politicsguys.com works too. I get both of those essentially, and also on our Twitter or Facebook, anything like that. But I'm totally willing to do that. Discord folks, let me know what you think about that as well. So we need to
problem solved.
Yeah, well, I'm willing to take. I've been thinking for a while. It's like we talk about a lot of stuff on this show all the time. We don't really do much direct action type of stuff to try to take what I would say is our bipartisan views and feelings and try to do something with those that's very kind of substantive. I would be willing to make this our issue, to try to see if we can find some consensus and common ground and build on this. And so I am dead serious about this. Folks, if you're interested in this, let me know, and we will see what we can do about this. So there you go. All right. Well, with that, Jay, I think we need to move from our regular show into the supporters segment, and we still have a lot of stuff to talk about, right? We're going to talk about the Senate.
We're decided a lot of
there's a lot of stuff here, right? That and the vote in Congress on guns, and maybe we could even have time to get into Biden's gas tax suspension thing. The January 6th committee, of course. A lot of this is going to depend on how long I can kind of last. I'm fading pretty quickly already here, but the point is there is a lot more to come. And if you're a Politics Guys supporter, you're going to hear that in just a minute. And if you're not, just remember, you can become a Politics Guys supporter. It's patreon.com/politicsguys. You can also support us at Venmo. We're at Politics Guys, or on PayPal. All of those support links are in the show notes and at politicsguys.com/support. And if you would like to get all this, but you're not in a position to financially support the show, totally not a problem. just send me an email, mike@politicsguys.com, and I will be happy to give you access to all of the stuff we put out. And as always, whether you're a supporter or not, we would truly appreciate it if you could subscribe, rate the show, leave a review on whatever podcast app you use, and share episodes on social media. That really matters a lot. Thank you so much.